So I'd like to focus the majority of my argument now on the constitutional right to free speech, which Ms. Regley has mentioned in her argument. And I think that obviously the court is limited by what's in the record, and the record is replete with a lot of statements by Ms. Regley, public statements by Ms. Regley, some related litigation, some not related litigation. But in the Tennessee case law, the court sort of waded into this area in BPR versus Parrish, a 2018 decision of the Tennessee Supreme Court, which is in our brief. It's 556 Southwest 3rd 155. And that was a case involving an attorney who made disparaging statements about some judges in some pleadings filed in the Tennessee Court of Appeals. And the Tennessee Supreme Court determined in that case that the reasonable or the sanctionability of those statements, I will say that the basis of using those statements as a basis for imposing discipline would be judged by an objective standard. That is, were the statements objectively reasonable when determining if they were made with reckless disregard for their falsity, because the attorney was saying that he didn't know the statements were false. He made the statements, but he thought they might be true. Well, under the Supreme Court's analysis, any reasonable attorney would objectively know that that you can't say the statements that he said without exhibiting reckless disregard, because they were so illogical and so unlikely and so preposterous.